All right, ladies and gentlemen, I have 9 o'clock. I'm going to call the dockets for announcements. We'll start off with Karnes County in the matter of the marriage of Gina Morales and David Cantu. Anyone? It's pro se. The matter of the marriage of Lawrence and Tiffany Welsh. I'll recall. 21016 in the interest of MRC, a child.
Your Honor, drop that setting. I don't have service.
All right. LaSalle County, Michael and Cynthia Few versus James Kelly et al.
Your Honor, this is Andy Alvoyd. I represent the defendant, the Kellys in this matter. What we have set for today is the special exceptions and our motion to strike the plaintiff's demand for abstracted title.
Good morning, Your Honor. This is Mark Paisley, and I represent the plaintiffs in this cause, and we are here.
Okay, how long to hear this?
I'm thinking it's 20 minutes, Your Honor.
No.
Or less, Your Honor. We agree.
Okay. All right. Well, I'm going to mark you 20 minutes. And have you had an opportunity to confer about this?
Your Honor, Mr. Paisley did send me an email that he agreed to my special exceptions, but I haven't seen an amended petition as of today, Your Honor. As to the demand for an abstract of title, Your Honor, we've not conferred on that.
Okay, well, do either of you have anything else on the docket?
No, sir, I do not.
Or Mr. Paisley? Mr. Paisley? Well, it looks like you went away. Hopefully he'll make it back. Atascosa County, San Miguel versus Peeler, that's been dropped by agreement. Wilson County, 12-12-7-11 in the interest of the Tackett children. No one? $16,846 in the interest of the Ivy children.
Judge, the attorneys have sent temporary orders to the coordinator's queue for you to review. There's actually 3 agreed orders that have been sent.
All right, well, I don't know if the coordinator's office has been open, so as I had nothing yesterday afternoon, I will look and see what I get. 18-4-2-8-5, interest of CRH and KGH children. All right, the marriage of Stacy and Christopher Knight.
Hey, Your Honor.
Sir. And Judge, we have emailed the divorce decree to you.
Okay. And are both of you ready to proceed?
Yes.
Okay, I'll mark you A. You'll be the first self-represented case that I call. All right, in re Robert Hampton.
Good morning, Your Honor. I'm Richard Douglas, work for State Counsel for Offenders. I'm Mr. Hampton's counsel.
And good morning, Your Honor. My name is Olivia Thayer with the Special Prosecution Unit. I am representing the state in this case.
Okay, and what do we have to hear?
Your Honor.
Go ahead, Richard.
Oh, sorry. Your Honor, we made a claim of privilege on some discovery that we released to the state, and the state answered with a motion to assess the privilege, and we're ready to argue it.
Okay. How long to hear that?
Your Honor, I think I need no more than 10 minutes to say what I have to say.
That sounds about the same for me.
All right, I'll mark you 20 minutes. And if there are copies of any documents I need to look at, if you would send them to me, I would appreciate it. All right. And Mr. Paisley, I see you're back. I'm gonna ask that you and Mr. Avaloy confer, and if you work out anything that you can, anything you can't work out, let's at least narrow the issues down, and I'll put you in breakout room number 1. Anyone else told to be here today?
I apologize. I'm having some technical difficulties apparently, but I am back. Thank you.
Yeah, yes, okay. All right, anyone else told to be here today, your case was not called? Okay, then let me look at the pro se case. We want to find a divorce decree. Okay, let me look at your proposed divorce decree. Okay, are both parties ready to proceed in the ninth case?
Yes, sir.
Yes, sir.
Yes, sir.
All right, and did we start this previously or not?
No,
No.
this is the first appearance.
Okay. All right, let me ask each of you to raise your right hands. Do each of you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, you put your hands down, and when you state your name, please, ma'am.
Stacy Annette Knight.
Okay, and your name for the record, sir?
Christopher David Knight.
Okay. All right, and Ms. Knight, prior to the time this lawsuit was filed, had you been a resident of Wilson County for 90 days in Texas for 6 months?
Yes, sir.
And you're married to Christopher Knight?
Yes, sir.
Okay. Has the marriage between the two of you become undermined due to a discord or a conflict of personalities, meaning that you're just not getting along?
Yes, sir.
Is there any likelihood that you're going to reconcile and live together again as husband and wife?
Probably not. We've already tried, sir.
All right. And when did the two of you marry?
June 23rd, 2012.
And how many children have been born to you since that date?
Just one.
And are you expecting a child?
Yes, sir.
Now, on your divorce decree, you are asking that you're going to be appointed joint managing conservators, but there's going to be a geographic restriction that you're going to continue to reside together?
For the moment, yes, because the year has been so rough. I don't feel right asking him to leave at the moment.
Okay. All right. And do you think that's in the child's best interest?
At the moment, I do, sir. We've been able to do it, trying to work out our marriage. So I don't see why it would be a problem now.
All right. And I need to tell you both that the law in Texas presumes that every single thing a married person owns is community property. So it's not a matter of whose name is on anything. It's not a matter of whether you're fighting over it. Anything that's valuable enough, there might be a lawsuit over it one day. It needs to be spelled out specifically who winds up with it in the divorce decree. If that doesn't happen, then the law presumes that I forgot to divide it in the divorce decree, and that the two of you still own it together, even though you're divorced. So I saw that there were various items listed in your divorce decree of property to each of you. Is there anything else that needs to be listed there?
Nothing that's of major concern that I'm aware of.
Okay. All right. And do you think the way you have your property and debts divided up is a fair way to do it?
As far as I'm concerned, yes.
Okay. And are you asking for to have a previous name restored?
Yes, sir.
Okay, and what is that?
It would be Stacy Annette Vaughn.
Okay, I see right there. All right, Mr. Knight, did you hear everything that your wife testified to?
Yes, sir.
And is everything that she said true and correct?
Yes, sir.
And do you also think that the proposed orders are in your child's best interest?
Yes, sir.
And do you have any questions for her at this time?
No, sir.
Your Honor, may I say something?
Yes, ma'am.
Okay, I wanted to state for his peace of mind, I'm aware that Texas is a community property state. And since we are both staying in the home, whenever he decides to move, I'm gonna get an appraisal done on the home and pay him half the amount that the home is worth.
Okay. And ma'am, I appreciate that sentiment, but you both understand that if that's not what the divorce decree says, that's just a handshake deal.
Yes, and we're both aware of that.
Okay, and you're asking me and you've both signed off on the divorce decree?
Yes, sir.
Yes, sir.
Okay, then. All right, I'll find I have jurisdiction to hear this matter. It's been on file for more than 60 days. The respondent has appeared in open court and agreed to the entry of the divorce decree and has also signed off on it. The petitioner had been a resident of Wilson County for 90 days in Texas for 6 months prior to the time this lawsuit was filed. The marriage between the parties has become undermined due to discord or conflict of personalities, and there's no present likelihood of reconciliation. There was one child born during the marriage and no other children were born, or adopted, or expected. And I find that the proposed division of the marital property, and one more time. And I find that the orders concerning the child are in the child's best interest, and I will approve them. And I will also find that the proposed division of the marital property and debt is just, fair, and equitable, and approve it. And I will restore the petitioner's previous name of Vaughn. Any relief that does not appear in the divorce decree is denied, so this is a final appealable order. Now, I need to let you know also that there is a document that you have to give to the district clerk's office that reports this divorce to Austin. That's called a BVS, or Bureau of Vital Statistics sheet. Have you prepared one of those already or filed one of those already?
I believe I did already, sir.
Okay. All right. Well, let me.
Judge, I believe that we do have that at the office.
Okay. All right. And would it be better, Ms. Bryant, for me to give this to you in chat or to e-file it?
Judge, if you could e-file, that would be better.
Okay. All right. Then I've signed the divorce decree. I will e-file it in just a moment. And you are excused. I'm not sure if the county offices will be open tomorrow or not. It may be Monday before you can get your copies of your divorce decree, but you'll be able to get them shortly.
All right, thank you.
All right. All right, Mr. Paisley, let me see,
I apologize, Your Honor. I keep getting disconnected and I'm trying to reach Andrew on the phone and I can't do that either. So,
all right. Well, let me get you back to breakout room
I appreciate it.
number 1. There you go. Okay. All right. Okay, the commitment of Hampton. Do we need Mr. Hampton present for this?
Your Honor, we have a waiver for personal appearance from Mr. Hampton, and my preference would be to have him, but given the trouble we have reaching him at all in the units, we propose to go ahead based on that waiver.
Okay. All right, and do you have a copy of whatever motion you filed or any response from the state?
Yes, Your Honor. I think Mr. Douglas just tried to email it again. I don't know if we have a personal email for you, but the email we have, he has sent it to. And correct me if I'm wrong, Richard, on that.
Your Honor, I just sent copies of the motion and our reply and a draft order to Lori Riley and to the coordinator's email.
Okay, well, their office is closed right now. If you could just post that to me in chat, that would be the quickest way to get it.
Okay, I'm gonna, Your Honor, we're testing my technology abilities here, but.
Okay, hopefully if you go to chat and click on either my name or everyone,
Okay.
give you an option to upload a PDF.
Oh, here we are. Okay.
It should say file. Hopefully can upload a file.
Your Honor, I see your name and I'm at your name, but I don't see a way to attach anything.
Okay, and off to the right, are you on a tablet or are you on a computer?
Yes, Your Honor, I'm on a laptop. Let me see if I can see what's going on here.
I'm also
All right, and
having some trouble.
yes, when I go to, let me go to everyone,
Okay.
and I can send to everyone, but it doesn't pop that up. If you click on chat to everyone,
Yes, I'm there. Yes, Your Honor.
I'm just posted a random order to everyone. Does it give you an opportunity to send that to everyone?
Okay.
Because when I went to your name in particular, it didn't give me that ability to send it just to you.
Your Honor, I'm sorry, I don't see the order. And how about I try to send one to you?
Sure. Did you receive a copy of a document in chat?
No, I didn't, Your Honor. I just sent you one that says comms check.
Right.
I don't know if you see
And
that.
I do not have the order in my chat as well, Your Honor.
Okay, let me just.
Your Honor,
send
you have
my
an email there? We could, there we go.
Yes, I'm sending it to you. I prefer not to broadcast it over YouTube, so I'll just send it to you.
Okay. Okay.
I mean, not that it's hard to figure out.
There we are. Okay, I have it, Your Honor. I'm going to send it right now.
Richard, do you need me to send mine, or are you just attaching all three as you did previously?
I think I'm going to forward the one I sent to Ms. Wilson, and that'll probably do the trick.
Sounds good. I appreciate it.
So, let me find that. Okay. Your Honor, I just hit send, so should be on the way.
Well,
The 3 attachments, the state's motion, our response, and then a draft order. And I'll try sending them directly too, just in case.
there it is. Okay.
I'm sorry, receive it, Your Honor?
Yes.
Okay. Okay, terrific.
All right. Give me a chance to look at this and then we'll get started.
Sure.
Give me a moment. Okay, I need to speak with someone right quick. I'll be back at, let's call it 9:45, and we'll jump right into this commitment matter, and then we'll follow up Ms. Cavazos with the attorneys in LaSalle County and see where they stand. But I'll be back at 9:45.
Thank you, Your Honor.
Thank you, Your Honor.
All right, Mr. Alvoyd, it looks like Mr. Paisley's been kicked off again. Did y'all get anything worked out before he left?
We do have an agreement, Your Honor, on both the special exceptions and the and our motion to strike the demand for an abstracted title. Want to wait around a few minutes for Mr. Paisley to come back on. That's fine, Your Honor. It's snowing outside anyway. I can't go anywhere.
Where are you at? Where are you this morning?
I'm in Honda.
Oh, in Honda. Okay, it's no snow in Floresville. I mean, it still hadn't all melted from Monday, but no snow this morning. Okay, that's fine. Whatever you would prefer to do, I'm going to start the other hearing, and if he signs back on, fine. If not, if you just post whatever, if you get an agreed order, post that whenever you have the opportunity.
Okay, thank you, Your Honor.
You're welcome, sir. All right. Okay, I looked briefly at the motion and the response on the Hampton commitment. Are both sides ready for that?
Yes, Your Honor.
Yes, Your Honor.
All right. So I guess the motion to compel is filed by the state. So go ahead, ma'am.
Yes, Your Honor. I'm just going to basically reiterate what's in the motion. Mr. Hampton is asserting the Fifth Amendment in regards to specific pages. My understanding are these pages are from his personal journal. This was not a custodial setting in which he made this journal. This was not interrogation. He is in sex offender treatment. It is my understanding that these are personal writings related to that, or just personal writings in general. And therefore, it's not an answer to an interrogation. It's just not a setting where the Fifth Amendment applies. I'd also like to point out, and I apologize for this, in my motion, I had accidentally cited the wrong case when I said it's on page 3, where the simple fact that someone is incarcerated does not ipso facto establish custody. I had accidentally cited that to the Rhode Island case that is supposed to be to the Herrera v. State case, which is cited a couple lines above that, so I apologize. In regards to the mental health privilege, specifically to page SCFO 180 is the bait stamp for that. The statute that we work under, the Texas Health and Safety Code, Chapter 841, specifically entitles the state to this kind of information. This whole case is about whether Mr. Hampton is a sexually violent predator. And for us to be able to prove that to the jury, we have to show that he is a repeat sexually violent offender and that he has a behavioral abnormality. Now, the behavioral abnormality is kind of where this mental health comes in. Our expert is going to talk about Mr. Hampton's own understanding of his offenses, his attitude. He's trying to get as clear a picture of Mr. Hampton as a whole so that he can give as accurate opinion as he can. And aside from that, this page, or going along with that, this page also falls under the exception of the mental health privilege, specifically TRE 510, I believe it is D and E, but I can double check that, and that it is specifically relevant to the case at hand. And in fact, again, it factors into our expert's opinion, and Mr. Hampton himself in his deposition stated that what he brought to the deposition he thinks is relevant to his case. I have the deposition transcript. I did not attach that to my motion, but I'm happy to send that to you with a cite to where he says that if you would like.
Okay, I think that would be appropriate.
Okay. I will go ahead and send that to your honor. And Richard, I'll attach you to that.
All right, anything else?
Not from the state, your honor, not at this time.
All right, and again, I'm at the house myself, so it's a little, I'm working on one monitor and I'm used to having two, so I have to flip back and forth. Go ahead, Mr. Douglas.
Thank you, Your Honor. And with your indulgence, I'm going to give you a little more background about this case since I'm not sure how much is out there for you. Of course, we have a different point of view from the state. And I'll come to the privilege assertion, but I'm not sure we even need to get to the Fifth Amendment assertion. In any event, Mr. Hampton's been incarcerated for 25 years within TDC as a result of criminal proceedings in this court. He's fully satisfied 1996 judgments of this court. In fact, his satisfactory conduct has led to his approval for parole, provided that he complete TDCJ's 9-month sex offender treatment program. He's in that program now and he's making good progress. And then, of course, after his release on parole, he'll be subject to lifelong obligation to register and report as a sex offender. So now at the end of this almost 25 years of incarceration, the state has filed a Chapter 841 commitment action. And for the record, we think that it should be pointed out that Mr. Hampton cannot be presumed to be a sexually violent predator. The state has a burden to prove that to a jury beyond a reasonable doubt, and that has not occurred. So from our perspective, with all due respect to my colleague, the state's practical objective here is to confine Mr. Hampton after the end of his sentence, to confine him again at the Littlefield total confinement facility, probably for life. Littlefield was built in the 1990s as a medium security prison. It's a prison today. And why do we say life? Because of the hundreds of men committed to Littlefield, only about 10 have been released. So now this Chapter 841 proceeding, when it reaches the jury, Your Honor, we expect the state is going to dwell on the merits of the criminal proceedings against Mr. Hampton in this court from 25 years ago. But the Chapter 841 proceeding is really a new action, separate and distinct from the causes that put Mr. Hampton in prison. The 841 proceeding required a new petition filed by the state. It's got a new cause number. And as a new action, we believe that the clock is reset to 0, including the privilege clock. So on this deposition, we want to say, and the deposition we're talking about, by the way, in this case, was actually on December 9th. It was a Zoom deposition. Mr. Hampton was in the Goree unit, 4 miles from my office, but we've never met. We asserted no privilege at all during the deposition in question. We asserted no privilege at all for any other discovery request prior to the appearance of this journal. And that was during the December 9th deposition. Mr. Hampton held it up to show the camera that he's treating this sex offender therapy treatment as seriously as he possibly can. So we became aware of that journal by accident. And only after we read each and every page did we assert any privilege for a modest piece of its contents. We produced 68 pages from that journal. And Your Honor, it's not 8.5 by 11, it's about 5 by 6. We produced 68 pages and withheld 10. And we immediately provided a privilege log, which the state has not faulted. And in our reply to the state's motion, we actually withdrew a claim that I had made to lawyer-client privilege. So there really only 2 assertions remain on the table: the mental health privilege and the Fifth Amendment privilege. So I'm going to talk about mental health first, Your Honor. As noted, it may not even be necessary to reach the Fifth Amendment because the text of Chapter 841 itself settles this mental health privilege question. Chapter 841 provides expressly in Section 841.1461 that a person who suffers from the behavior abnormality that Ms. Thayer mentioned is not a person of unsound mind for purposes of Article 1 of the Texas Constitution. Just not. And logically, and contrary to the motion, we don't think that this is a mental health proceeding. And there's authority for that coming out of the Court of Appeals in Beaumont from 2016, where the court made clear that you can commit with no psychiatric and no medical testimony at all. It's not required. So Chapter 841 itself provides that this is not a mental health proceeding. Logically, the exception to the mental health privilege would not apply because the state simply cannot be a party relying on the respondent's mental condition as part of the claim if it's not a mental health proceeding. In addition, Your Honor, in the motion, the state discusses Section 841.142 about a quote entitlement to this information. Your Honor, that section only deals with information sharing among government entities. It is not a discovery provision. It imposes no discovery obligation on Mr. Hampton, and it does not override the privilege found in the rules of evidence. In fact, the rules of evidence are not mentioned at all in this chapter, and the statute provides there's no implied avenue to sidestep them, and there's no preemption section. So we believe that that mental health privilege was fairly and narrowly invoked, and we would ask the court to sustain it. So if the court agrees to sustain the mental health privilege, there's really no need to reach the Fifth Amendment claim. Although, you know, we're not here to waive it, but we do note first that the state has not disputed the applicability of the amendment to Chapter 841 proceedings. In fact, it was the state that raised Miranda, not the respondent. And yes, we did refer to the case that Ms. Thayer now, you know, I think fairly points out was an error, but that case called Innis versus Rhode Island actually helped us make our case because it broadened the sweep of Miranda to the functional equivalent of custodial interrogation. So what the state is arguing here is that a person confined in TDCJ and questioned in a new proceeding is not in custody for purposes of the Fifth Amendment. Second, that a deposition demanded in a new proceeding by a prosecutor seeking statements for use against the declarant in what is at least constructively a criminal jury trial is not interrogation. And third, that a person confined behind bars, walls, razor wire does not act under duress. Your Honor, we disagree with all three of those assertions. Basically, the state invites the court to overrule our modest claim of privilege, accept this, you know, and accept this civil proceeding facade, essentially, and disregard the substance of the 841 proceeding, namely the continued incarceration for life of a person who has satisfied all obligations imposed by this court's judgments in 1996 and who is not reoffended. Your Honor, I know we're in a courtroom and not the legislature, but in conclusion, I would like to at least mention what I think is an important policy dimension to the state's effort to defeat this modest claim of privilege. The sex offender treatment program should not become a salt lick for Chapter 841 commitment, where offenders who try to do what the program asks them to do later hear their candid personal reflections from their journals, which TDCJ itself has encouraged. Later, they hear these reflections read out loud by the state and probably distorted to a Chapter 841 jury. And we think that participants in this program faced with this prospect are going to be concerned about the consequences of candor in a program where candor ought to be encouraged. So we believe that granting the state's motion in this case in any event is going to be counterproductive to the program's objectives, particularly since Chapter 841 itself provides that this is not a mental health proceeding. Nothing further at this time.
Okay, all right. I want to look at your case law and look at this.
Your Honor, would you like me to send you the site from the Beaumont case?
If it's not in your reply, please.
Yeah, it is. It's in the reply.
Okay, no, I'll go and look it up. I will look it up. And Ms. Thayer, do you think there's any public policy dimensions of the fact that in the Code of Criminal Procedure, the one thing that a search warrant can never issue for is the personal writings of the accused?
I do understand, Your Honor. I
know it's not a search warrant, but.
Right. This is a civil proceeding, so we do have to operate under civil rules. There are only a couple instances where the criminal proceedings or criminal rules apply to these cases. It's very interesting, kind of fine line. I do have multiple case law that I can send, Your Honor, where this does specifically state these are civil proceedings.
No, I understand that, but.
And I do understand that personal writings are typically protected, but this is part of his sex offender treatment, which is incredibly relevant to these cases. The point of this law is to be, the primary purpose of it is for treatment. If Mr. Hampton is found to be a sexually violent predator, he does go to Littlefield. It is not a prison. It is a tiered program that he must work his way through to show that he is able to be safely released into the community. And we do have case law that shows the primary purpose is for that treatment and to protect the community. I do understand he has served his sentence and that he is working through this sex offender treatment, which is great for him. If we see enough improvement, we send all this information to our expert. If that expert sees, I see enough improvement here, I do not think he has a behavior abnormality, then he changed his opinion, and this case, might just be non-suited. But at this point, given all the information my expert has, he still sees that behavior abnormality present. And part of that information and part of what makes his opinion as strong as it can be is these personal writings. Mr. Hampton's own view of himself, of his actions, of his behavior is very important to his risk of understanding whether he has a behavior abnormality.
Okay, all right. I will take this under advisement, look at it, get something signed today.
Thank you.
Your Honor, may I just be heard on I'm sorry, I hate
Yes,
to
go
prolong
ahead.
this, but on 2 points. On the issue of whether Littlefield is a prison, Your Honor, it was built in the 90s as a medium security prison. It's housed hundreds of offenders from Texas and at least 3 other states. And the statute itself refers to the tiered program as beginning, and I'm quoting the statute 841-0831, a total confinement facility. And that's what Littlefield is. It's a total confinement facility. And the idea that Mr. Hampton's going to treatment, I don't mean to be too crass, but under the Texas Administrative Code, employees at Littlefield are entitled to use chemical and inflammable agents and leg ankle shackles on residents of Littlefield, people who have completed their sentences, who've been paroled, and then have been scooped up and put in Littlefield. They're entitled to use these things against them. And with all due respect, that's not treatment. We appreciate the opportunity to be heard. Civil commitment in Texas started out as civil with Addington versus Texas in 1979, where the Supreme Court of the United States said this is a civil proceeding. But since then, the Texas State Legislature has steadily and unmistakably retreated from that position. It's a beyond a reasonable doubt standard, which the court itself in Addington called the criminal law standard. The 841 jury selection process is directly coupled to the Code of Criminal Procedure in Texas, 12 members in district court under Chapter 33. The statute itself describes confinement in a total confinement facility, producing a result that's indistinguishable from criminal conviction. The Texas legislature has created a confinement scheme which results in confinement for life for nearly everybody who goes through this process. People who have finished their sentences and been approved for parole are behind razor wire with hardened movement controls and physical restraints. Even the legislature conferred exclusive authority to bring these provisions or these 841 cases on district and county attorneys, not on the special prosecution unit where Ms. Thayer works, which is in keeping with criminal proceedings. They've legislatively characterized as a felony of the 3rd degree the violation of any commitment requirement, and they use bench warrants in a civil proceeding for people who haven't even been released yet. So, Your Honor, this civil facade, it's harder to maintain with every legislative step toward a criminal proceeding, and it's only a matter of time before the right case goes up on appeal to end the fiction. So we appreciate the opportunity to be heard on that.
Okay, I will look at this today.
Thank you.
Thank you, Your Honor.
All right, Mr. Paisley, before you get kicked off again.
Yes, Your Honor, and I'm very sorry about this, and we're doing our best to hang in there.
Anyway, it's
I'm happy
happening a lot.
I don't know if you've had a chance to speak with Andrew, but we have an agreement to announce to the court, and he is prepared to do so.
All right, I think he's already announced it, but go ahead, sir.
Very
Yeah,
good. Just
Your Honor, the agreement is that within 7 days, Mr. Paisley will amend his petition to specifically provide that they are claiming to adversely possess only the surface estate to the subject property. Mr. Paisley will, or the plaintiff will identify the individuals who they claim they adversely possessed from. They will, the plaintiffs will take out their claims for attorney's fees in this matter and plead a straight up trespass to try title lawsuit. And then as to the second item on my motion, Your Honor, the demand for an abstract of title will be stricken or withdrawn, Your Honor. And I can prepare, we may have lost Mr. Paisley, but I can prepare agreed orders, hopefully within the first part of next week when things kind of warm up here. Send those to Mr. Paisley for his review and signature, and then submit those to the court.
All right.
And Judge, and we lost Mr. Paisley.
Yeah, he's going. All right, and that's fine. Okay, so I'll just mark this reset on request and.
Okay. Well, I was hoping that
Entry date.
Go ahead, Your Honor.
Do you need an entry date or?
I was hoping that we get this orders agreed or entered by the court today, Your Honor, to, keep things.
Right. Just as soon as you get it signed up or signed, just to submit it to the coordinator's office and or e-file it, and I'll sign it when it gets to me.
Okay. All right, Judge.
So I'll sign it as soon as possible.
Okay. And I've got no help up here, Judge. We're burning off snowed in, and nobody's even coming to the Honda office except for me with this weather. So I'll try to get it, hopefully get it drafted up tomorrow, get it to Mr. Paisley, and submit it to your court coordinator for entry.
Okay, yeah, it's about to start falling out, and we'll see how much worse it gets with all the broken pipes. We've been pretty lucky in Floresville so far.
Yeah, well, I hope your luck's
The last big freeze was 89. I was in law school, and I tried to get a job down on the coast, and I had an interview with a law firm in Corpus. And just as I walked in, the secretary put a call in to the attorney, and he said, "I'm sorry, young man, but my family's been using the restroom in the gas station down the street for a week, and the plumber just called and said he can be there in half an hour, and I'm leaving. I'm not going to interview you. I'm sorry you drove down here." I said, "I understand." So he took off.
It's a mess.
It's a mess. All right, everyone is released. Mr. Cedillos, did you have anything else?
No, Your Honor, I was just listening to the arguments.
Okay. All right, then I will end court, and I will see everybody. Possibly, Ms. Cavazos, we may have court tomorrow. Let's see if we need to have court for Kufus. Otherwise, I'll see you Monday.
Okay, I'll be waiting
Right.
for the email.
Sounds
And it's
good.
pouring over here.
Rain or snow?
Rain. I mean snow. Lots
Oh,
of
okay.
snow.
Maybe we'll get some more.
There's a little bit of sleet out